In the previous lesson, we outlined the rule of law as a basic principle of the UK Constitution and the UK's constitutional framework. This lesson is going to examine a very, very famous interpretation of the rule of law coming from arguably one of the greatest constitutionalists and constitutional theorists that we've ever had in the UK, this obviously being A.V. Dicey. We're going to talk about what A.V. Dicey interprets the rule of law to be and to mean, and we'll explain the importance of this interpretation. So, the last lesson looked at the rule of law in a more general framework, talking about the difficulty getting some kind of definition, talking about Joseph Raz's perception of the rule of law and a number of the different characteristics, talking about the fact that when we come to define the rule of law, we actually spend more time looking at different things that the rule of law could be and some of the elements of the rule of law rather than trying to come up with a specific and a coherent and contingent definition itself that is perfectly self-sustaining. Well, in the same way that we looked at Joseph Raz's theories of the rule of law in the previous lesson, this lesson is going to look at A.V. Dicey's theory of the rule of law. It's a little bit more simple. There's a few less characteristics that Dicey associates with the concept of the rule of law. And ultimately, in his part 2 of his introduction to the study of the law of the Constitution from 1885, one of the aforementioned cited works of constitutional theory in the United Kingdom, in fact, arguably one of the major sources of the UK's constitution, which we'll get to in the future, what A.V. Dicey does is elucidate what he believes to be just 3 major principles which essentially codify and enshrine the rule of law. And these 3 main principles are as follows. We will get to them in a second, but ultimately he himself understood the rule of law to be one of, if not the most important, and one of the most fundamental principles of the UK Constitution. Now, there's sometimes a bit of back and forth, a bit of debate about what comes before the other between the rule of law and the principle of parliamentary sovereignty. And there are lots of different arguments for why the rule of law is more important than parliamentary sovereignty. There are lots of arguments why parliamentary sovereignty is more important than the rule of law. But suffices to say that sovereignty of parliament and the rule of law are the 2 most important principles, arguably, of the UK Constitution. The 3 fundamental principles of the rule of law, then, are elucidated as follows by A.V. Dicey. He argues that, firstly, no one should be punished except for a violation of the law. Part 2 is that nobody is above the law is equal. And then part 3 relates to the supremacy of the ordinary law. Okay, those are the 3 principles. So better than Joseph Raz's 7, 8, 9 or 10 principles that sort of encompass ideas relating to the rule of law, we only have to deal with 3 principles and have to talk about them in a little bit more detail. So principle 1 is that no one should be punished except for a violation of the law. This is the view, essentially, that the law should not be imposing arbitrary restrictions, arbitrary power over the citizenry without the due process of law. It's very, very simple. Arbitrary power is subordinate to the authority of the law. This elucidated some basic principles that we see in not only the Glorious Revolution of 1688, when Parliament invites William of Orange to essentially rule over and reign, replacing James II. It also is elucidated in the first 2 articles of the 1689 Bill of Rights, and it makes complete sense. You shouldn't be subjected to the force of the law without the due process of the law. Okay, there is a sort of yin and yang that exists within the concept of law itself, that tells us that a violation of the law is the only is a condition for the enforcement of arbitrary of power, at least over the law, because otherwise it would be arbitrary. Law cannot be arbitrary, therefore there has to be this due process of law that exists. In addition to the due process of law and the lack of arbitrarity of law, we also have the idea of the equality of law. Okay, the law the law ought to be applied equally to every person. That's what the law is equal refers to. The idea of the equality of law. Very, very simple. Okay, not only does this entail that no person is above the law, but it also entails that there is no bias or arbitrary discrimination of individuals who are under the law itself. So not only is there no such thing as a person who exists outside of the law, but also for everybody who exists inside of the law, there is no discrimination on the basis of arbitrary bias. Okay, now there's a little bit of debate about this one, because ultimately and theoretically you could make the argument that the monarch is above the law, because the monarch is the person who to which all of legal authority and sovereignty comes from. They are the sovereign, but the extent to which the monarch can actually break the law is debatable, because even though theoretically the sovereign exists as above the law, you have the fact that the power of the sovereign is where law enforcement comes from. You have things like the Crown Prosecution Service. When you have a criminal case, it is the Crown versus the defendant. But if the monarch was to actually break the law, it would spark quite an interesting constitutional debate, and the question of whether or not the law is actually something that the monarch is subjected to is one that it's sort of a grey area in terms of the Constitution. It's a murky ground that ultimately we may have to just wait and see if the monarch ever does break the law as to whether or not it actually applies equally. The final principle then is the idea of supremacy of ordinary law. This is the view that the general principles of the Constitution are derived from the ordinary law. At the time, this represented the law of judicial decisions, the judge-made law of the common law, essentially. And essentially what A.V. Dicey does is note that this is particularly true regardless of whether or not the particular law is actually good or bad. So the argument here goes that Dicey is rejecting the notion that there exists some higher authority within the UK Constitution. And so he is rejecting the idea that there is some kind of higher entrenched legal system that would exist in, for example, a codified document like the US Constitution. So in recognizing that there is no codified constitution in the UK, and therefore there is no higher constitutional law that exists similar to that of the provisions of the US Constitution, that means, therefore, that the ordinary law that is non-constitutional is supreme. That is where the highest source of authority begins and ends. At the time, this is representative of the common law, because legislation wasn't as pertinent at the time, but it could also be representative as the idea and the principle of parliamentary sovereignty, sort of elucidating parliamentary sovereignty in this principle, but also making it very clear that the point of this essentially, the point of this principle is that there is no delineation between ordinary law and higher law. Ordinary law is the supremacy, is the supreme kind of law that exists.